Case 1. Kailee Smith Parks and Linwood Allison Jr. April 10, 2025. Franklin County, Ohio. There are places in every American city that exist without fanfare. Residential streets where the houses sit close together, where children ride bikes in the early evening and neighbors wave from front porches, where nothing about the exterior of any particular home would cause a person passing by to pause or wonder. The Reynoldsburg area, situated along the eastern edge of Columbus where the city begins its transition into the quieter rhythms of suburban Franklin County, is exactly that kind of place. Families live there. Children grow up there. Life moves forward there with the ordinary, unannounced momentum that most communities take for granted. It is in places like this, in the most unassuming settings, behind the most ordinary-looking doors, that some of the most devastating cases in Franklin County's legal history have unfolded. And among all the cases that Franklin County prosecutors, investigators, and child welfare advocates have encountered in recent years, the case of 4-year-old Kailee Smith stands in a category that those who worked it describe with a particular kind of gravity. Not because child abuse cases in Columbus are rare, they are not, but because of what the evidence in this specific case revealed, because of what it documented, because of the completeness with which it captured what this child endured. Kailee Smith was 4 years old. He was a child at the age when the world is still almost entirely made up of wonder, when language is growing rapidly, when questions come constantly, when every new thing encountered is processed with the total openness that only very young children carry into their experiences. He was 4 years old, and he lived on the eastern edge of Columbus, and he was known to the people around him in the way that small children are known, by their energy, by their voices, by the particular presence they bring into whatever space they occupy. Kailee Smith Parks was Kailee's mother. Linwood Allison Jr. was the man who shared the home with her, her live-in boyfriend, the adult male presence in the household where Kailee spent his days and nights. In the legal proceedings that followed the investigation into Kailee's death, both of these individuals would be named as defendants in one of the most extensively documented child abuse cases Franklin County had processed in years. The case came to the formal attention of Franklin County law enforcement and prosecutors in the context of an investigation that culminated on April 10, 2025, when the events that had been building inside that Reynoldsburg home reached a point that could no longer be concealed. The precise sequence of events that led investigators to the home on that date is part of the active legal record of the case and has not been fully disclosed in public court filings available at the time of this documentary's production. What has been disclosed, what has entered the public record through the grand jury indictment process, through prosecutorial statements, and through the legal filings associated with the case, is both comprehensive and profoundly disturbing. Franklin County prosecutors, in presenting their case to the grand jury that would ultimately return an indictment against both Smith Parks and Allison Jr., told the assembled jurors that the evidence in this case included home video footage. That detail, the existence of video documentation of what had occurred inside the home, is one that investigators and prosecutors described as among the most significant evidentiary facts in the case. In the landscape of child abuse investigations, physical evidence and witness testimony are frequently the primary tools through which prosecutors build their cases. Video documentation of the abuse itself is rare, and its existence in this case meant that the grand jury was not being asked to evaluate a reconstruction of events or to weigh conflicting accounts of what may or may not have happened. They were presented with a direct visual record. According to prosecutors' statements made in connection with the indictment, the footage documented Kailee being subjected to severe and sustained physical harm. It documented evidence of starvation, of a child being denied the food that his growing body required to function and develop. And it documented the use of water-based harm against the child, a form of abuse that prosecutors characterized in their grand jury presentation as part of a deliberate and systematic pattern of treatment directed at Kailee over an extended period of time. The term systematic is one that appears in the legal and prosecutorial framing of this case with notable frequency, and it is important to understand what that word means in the context of a criminal prosecution. Systematic abuse, as prosecutors define it, is not the product of a single moment of lost control. It is not an isolated incident that went too far. It is a pattern, a recurring, deliberate, ongoing course of conduct directed at a victim over time. The indictment against Smith Parks and Allison Jr. reflected precisely that characterization. The grand jury was asked to consider not a single event on April 10, 2025, but a course of conduct that investigators had documented as having continued for a period leading up to that final date. Kailee Smith Parks and Linwood Allison Jr. were both indicted on the most serious charges available under Ohio criminal law. Both faced charges of aggravated murder and murder in connection with Jakai's death. Both entered pleas of not guilty following their arraignment in Franklin County Court. Both remained in the Franklin County legal system as of the time this documentary was produced, with their cases proceeding through the pretrial and trial preparation phases of Ohio criminal procedure. Beyond the primary murder charges, the indictment laid out an additional architecture of criminal accountability that reflected the breadth of what investigators had uncovered. Kailee Smith Parks faced 20 additional counts related to child endangerment, a number that spoke not just to a single incident, but to the documented history of what Jakai had experienced in that home. Linwood Allison Jr. faced 22 additional counts of child endangerment, a number that exceeded even the count against the child's biological mother. In the legal framing that those numbers represent, prosecutors were communicating to the court, to the public, and to the record that Allison Jr.'s role in what happened to Jakai was not peripheral or passive. It was active, documented, and extensive. For the Franklin County child protection community, the questions that this case raised, and that it continues to raise as it moves through the court system, are questions about the systems of oversight and intervention that are designed to identify children in exactly this kind of situation before the situation reaches its worst possible conclusion. Jakai Smith was a child in Columbus. He was a child whose suffering was documented on video. He was a child whose situation was happening inside a home in a neighborhood where people lived their lives within a short distance of what was occurring behind that door. And the systems that exist to protect children did not reach him in time. That reality, difficult, painful, and important, has driven conversations within Franklin County Child Welfare Services, within advocacy organizations that work on behalf of at-risk children in Central Ohio, and within the broader community of people who follow these cases and believe that understanding them is the first step toward preventing the next one. What are the signs that a child is in danger? What does a neighbor, a family member, a community member do when they suspect that something is wrong inside a home where a young child lives? What does the reporting system look like? And how does a call translate into an investigation? And how does an investigation translate into a child being removed from danger before the danger becomes permanent? Those questions do not have simple answers, but they have urgent ones. In the case of Jakai Smith, its visibility, its documentation, the seriousness with which Franklin County's legal system has treated it, has given child welfare advocates in Columbus one of the most powerful and sobering examples of why those questions matter. Jakai Smith was 4 years old. He lived in the Reynoldsburg area of Columbus. He deserved every year that should have followed his fourth. He deserved the chance to grow up, to learn, to experience the world with the openness that 4-year-olds bring to everything they encounter. What he experienced instead is documented in the court records of Franklin County, in the evidence assembled by investigators, and in the indictment that names the 2 people charged with responsibility for what happened to him. The legal process is ongoing. The trial that Franklin County prosecutors are preparing to bring forward will place the full weight of the evidence before a jury and before a judge. When that process concludes, Jakai Smith's case will have its final legal chapter. Until then, his name lives in the court record, in the awareness of the Columbus community, and in the determination of every person who works in child protection in Central Ohio to ensure that what happened to him does not happen to another child on another quiet street, in another ordinary-looking neighborhood. If you or someone you know has concerns about the welfare of a child, the Child Help National Child Abuse Hotline is available at 1-800-422-4453, 24 hours a day, 7 days a week. You do not have to be certain. You do not have to have proof. You only have to make the call. The professionals on the other end of that line are trained to help you evaluate what you have observed and to take the steps that are appropriate for the situation. A call like that, a single call, made in uncertainty, made with imperfect information, is the kind of call that has saved children's lives in Franklin County and across the country. Jakai Smith deserved that call. The legal system is now doing what it can. The community must do the same. If this case moved you, if it made you think differently about the children in your own community, please take a moment right now to like this video, leave a comment below telling us what you think, and subscribe to Cold Case Hour so you never miss another documentary like this one. Your engagement is what allows this channel to keep telling these stories and to keep these children's names in the public consciousness where they belong. Like, comment, and subscribe, and let's keep going. Case 2, Ashley Fagan. April 13, 2025. Franklin County, Ohio. The Franklin County Courthouse in Columbus has witnessed a great many sentencing hearings over the years. It has heard judges deliver verdicts and pronounce sentences in cases that run the full spectrum of human conduct, from the minor to the catastrophic, from the impulsive to the premeditated. Judges who have served on Franklin County's bench for extended periods develop, by necessity, a kind of professional equanimity in the face of the worst that human behavior can produce. They have seen things. They have heard testimony. They have presided over cases that most members of the public will never encounter directly. And yet, by the accounts of those present in the Franklin County courtroom during the sentencing hearing for Ashley Fagan in December of 2025, there was something in this case that produced in the room a quality of grief that even experienced courtroom observers noted as different. Different because of the age of the victim. Different because of the nature of the harm that the medical and legal record had assembled. And different, perhaps most of all, because of the particular cruelty of the circumstances. Because the child at the center of this case, 6-year-old Eva Bretz, had not been the victim of a stranger, of an institutional failure, of some abstract breakdown in a system. She had been harmed by the person she trusted most completely, by the person whose primary purpose in life, from the moment Eva was born, was to protect her. Eva Bretz was 6 years old. She was a Columbus child, a little girl living on the near side of childhood, at the age when school has begun to open up the world, when friendships are forming with the particular intensity that early childhood friendships carry, when the days are full of the small but significant discoveries that accumulate into a growing sense of self and place. She had a name that her teachers knew. She had a face that her classmates recognized. She had, by all indications available through the court record and the investigative documentation assembled in connection with her case, a presence that those around her noticed, and that her absence would not have gone unregistered. That absence did not go unregistered. It was registered by the Columbus investigators who responded to the emergency call on April 13, 2025. It was registered by the medical professionals who examined what had happened to Eva. And it was registered, with the full institutional force of the Franklin County criminal justice system, in the proceedings that followed. Ashley Fagan was Eva's mother. The investigation into Eva's death began when emergency personnel were called to the Columbus home, where Eva lived with her mother and the man who shared the household, Fagan's live-in boyfriend, whose name has been included in the court record of this case, but who, as this documentary will address, did not ultimately face legal consequences through the court system. When first responders arrived at the Columbus home on April 13, 2025, what they found, and what was subsequently documented by the medical and investigative teams who became involved in the case, painted a picture that would take months to fully articulate through the legal process, but that was apparent to those on the scene as something serious and deeply wrong. The medical examination conducted in connection with Eva's death was extensive, and the findings it produced were, in the clinical and investigative language that was applied to them, among the most significant evidentiary elements of the case against Ashley Fagan. The examination documented evidence of severe internal injury, the kind of internal injury that medical professionals who work in pediatric medicine and pediatric forensics are specifically trained to identify and interpret. The injuries documented were not consistent with a single incident. They were not consistent with an accident. They were not consistent with any explanation that would support a narrative of an isolated event that had gone tragically wrong. What the medical record showed, what the combination of physical examination, imaging studies, and autopsy findings assembled into a coherent picture for investigators and prosecutors, was a pattern that had developed over a period of weeks. A pattern that reflected repeated harm directed at a 6-year-old child over an extended period of time, harm that had been ongoing, harm that had been inflicted and then concealed, harm that had escalated until the day of April 13, 2025, when it could no longer be concealed because Eva Bretz was no longer alive. Among the specific findings documented in the medical and court records of this case, findings that prosecutors incorporated into the charges against Ashley Fagan and that formed the factual backbone of the guilty plea that ultimately resolved the case, was evidence of severe damage to internal organs that medical examiners described as the result of significant physical force applied over time. The record also documented evidence of a chronic pattern of physical harm spanning several weeks prior to April 13th, a timeline that prosecutors would rely upon in arguing that what had happened to Eva was not a single catastrophic event, but a sustained course of conduct that had continued long enough to leave a traceable medical history. Ashley Fagan, when confronted with the assembled weight of this evidence, made a legal decision that her attorneys and the court would subsequently process through the formal mechanisms of the Ohio criminal justice system. She chose to enter a guilty plea. She did not take her case before a Franklin County jury. She acknowledged, through the guilty plea process, her legal responsibility for what had happened to Eva Bretz. The charges to which she pleaded guilty were involuntary manslaughter, child endangering, permitting child abuse, and obstructing justice. Each of those charges, considered individually, tells a partial story of what the legal record documents about Fagan's role in Eva's death. Together, they form a comprehensive account. The involuntary manslaughter charge addresses the death itself and Fagan's role in causing it. The child endangering charge addresses the ongoing conditions to which Eva was subjected in the weeks prior to April 13th. The permitting child abuse charge addresses Fagan's legal responsibility for allowing harm to be directed at her daughter without intervention. And the obstructing justice charge addresses what investigators determined had occurred in the period between the harm being done and the moment it was reported, the steps taken to conceal what had happened, to delay the involvement of law enforcement and medical professionals, and to interfere with the investigation that followed. The sentencing hearing in December of 2025 produced a sentence that Franklin County's legal community noted as among the most significant delivered in a child endangerment and manslaughter case during that period. The judge, after hearing the arguments of prosecutors and defense counsel and reviewing the full record of the case, sentenced Ashley Fagan to a term of 18 to 23.5 years in the Ohio State prison system. The sentence reflected both the severity of what Eva had endured and the range of conduct, from the direct harm to the concealment, for which Fagan had been held legally responsible. The judge's remarks from the bench during the sentencing, as reported by those present and captured in the court transcript, addressed the particular gravity of this case, the fact that Eva Bretz was 6 years old, the fact that the harm she suffered had continued over weeks without intervention, and the fact that the person who had been positioned by law and by nature to be Eva's primary protector had instead been the person responsible for her suffering and, ultimately, for her death. Judges do not often make extended remarks at sentencing in cases where a defendant has pleaded guilty. In this case, by the accounts of those in the courtroom, the judge found it necessary to speak at some length because the record required it. There is a second dimension to the case of Eva Bretz that adds a layer of tragedy that the court proceedings could not fully address. The live-in boyfriend, the man who shared the Columbus home with Ashley Fagan and Eva, the man who had been identified by investigators as a person of significant interest and who was facing serious criminal charges of his own in connection with Eva's death, did not live to face those charges. Before detectives were able to complete the process of apprehending him for the charges related to Eva's case, he died by suicide. His death meant that the legal accounting for Eva Bretz would never be fully complete, that one of the adults in the home where she suffered would face no courtroom, no judge, no jury, no sentence. That outcome, deeply unsatisfying to prosecutors, to victim advocates, and to the family members and community supporters who had followed the case, is not uncommon in high-profile child abuse cases where multiple defendants are involved. The person who escapes legal accountability through death does not escape the moral accounting of what they did. They do not escape the historical record. They do not escape the knowledge, available to anyone who reads the court documents in this case, of what they are documented to have done and what they were facing as a result. For the child welfare community in Columbus, the case of Eva Bretz has become a reference point for conversations about how children who are enduring prolonged harm within their homes, harm that leaves a medical trace, harm that develops over weeks, can be identified more quickly, responded to more effectively, and removed from danger before the harm reaches a point of no return. Eva was 6 years old. She was in school. She was in a community. She was visible, in the sense that any 6-year-old child living in an American city is visible to the various systems and institutions that touch children's lives. And yet the harm she was experiencing was not identified in time. The mandatory reporting systems that Ohio law establishes for teachers, medical professionals, social workers, and others who work with children exist precisely to create the kind of early identification infrastructure that cases like Eva's underscore the critical importance of. When those systems work, when a teacher reports a concern, when a pediatrician flags an unexplained injury, when a school nurse asks a question and gets an answer that prompts a call, children's lives are saved. When there are gaps in the system, when reports are not made or not acted upon with sufficient urgency, children like Eva Bretz pay the price. Ashley Fagan is serving her sentence in the Ohio State prison system. Eva Bretz is gone, and the Franklin County Court record stands as the permanent, detailed, legally verified account of what happened to a 6-year-old girl in Columbus, Ohio, in the weeks leading up to April 13, 2025. Eva Bretz is remembered. Her name belongs to the record of this case, to the advocacy work that has been done in her memory, and to the determination of every person in Franklin County's child protection community to ensure that the systems designed to protect children like her are stronger, faster, and more effective because of what her case revealed. The law delivered what it could. The community owes it to Eva to deliver the rest, through awareness, through reporting, through the willingness to make a call when something feels wrong. Please like this video right now, leave a comment below, and subscribe to Cold Case Hour. Eva Bretz deserves to have her story heard. Your engagement helps make sure it reaches the people who need to hear it. Case 3, Pammy Maye. February 14, 2024. Franklin County, Ohio. There is a particular dimension of trust that the foster care system asks communities to extend, not just to the state agencies that administer it, not just to the caseworkers who manage its caseloads, but to the individuals who are approved as foster parents and who take children who have already experienced instability and loss into their homes. Foster parents, in the framework of Ohio's child welfare system, are people who have passed background screenings, who have completed training, who have been evaluated by the professionals responsible for making placement decisions, and who have been found suitable to serve as temporary caregivers for children who, for reasons beyond their control, cannot safely remain in their biological homes. That trust, extended by the state, extended by the children placed in foster care, and extended by the broader community that relies on the system to function with integrity, was catastrophically violated in the case of 5-year-old Darnell Taylor. And the date on which the full weight of that violation became undeniable to the world was February 14, 2024, Valentine's Day, a date that now carries in Columbus a meaning entirely different from the one most people associate with it. Darnell Taylor was 5 years old. He had come to live in the Columbus home of Pammy Maye through the mechanisms of Ohio's foster care placement process, a process that had evaluated Maye, had found her suitable, and had placed a vulnerable 5-year-old child in her care. Darnell's circumstances prior to entering the foster care system are not the focus of this documentary. What matters for the purposes of understanding what happened to him is the simple, devastating fact that when the state of Ohio placed Darnell Taylor in Pammy Maye's home, it placed him there with the expectation and the legal obligation that he would be safe. He was not safe. He was not protected. And on February 14, 2024, the full truth of what had happened to him began to emerge in a way that sent shockwaves through Columbus, through the Ohio foster care community, and through the broader national conversation about child welfare and the protection of vulnerable children. The call that initiated the investigation into Darnell's death came not from a concerned neighbor, not from a teacher who had noticed something wrong, not from a mandatory reporter who had flagged a concern through the established system. The call came from Pammy Maye's own husband. He contacted law enforcement and told them that his wife had caused the death of 5-year-old Darnell Taylor. That call, made from within the home where Darnell had been placed, made by the man married to the woman charged with his care, set in motion one of the most urgent and visible law enforcement responses that Ohio had seen in connection with a missing or endangered child in years. The Ohio Amber Alert system was activated, broadcasting Darnell's name, photograph, and description across every major platform, every highway alert system, and every media outlet in the state. The public was mobilized. The search was broad and intensive and conducted with the full resources that the Ohio law enforcement community could bring to bear. But Darnell Taylor was not missing in the way that the Amber Alert system is designed to address. He had not been taken by a stranger. He had not wandered away. He was not somewhere in the state waiting to be found by a search team that arrived in time. The information that Pammy Maye's husband had provided to law enforcement, combined with the investigative work conducted in the hours that followed the initial call, led authorities not to a living child, but to a location in Columbus that no investigator, no child welfare professional, no member of the public could have anticipated: a sewage drain in the city where Darnell had lived, and where he had been placed to be kept safe. The discovery of Darnell's remains in that location, the search for a child, activated by an Amber Alert, ending not with a rescue but with a recovery, was, for the Columbus law enforcement community and for the city as a whole, a moment of profound and painful reckoning. The autopsy conducted following the discovery of Darnell's remains was performed by forensic specialists whose findings determined that the cause of the 5-year-old's death was suffocation, that his life had been taken through an act that required deliberate and sustained physical action by an adult against a child who was not capable of defending himself. The finding of suffocation, in the context of the information that Maye's husband had already provided to law enforcement, and in the context of what investigators were assembling about the circumstances of Darnell's time in the Maye household, left prosecutors with a clear direction. This was a case of intentional criminal conduct resulting in the death of a child. Pammy Maye was located and taken into custody in Northeast Ohio, some distance from Columbus, following the Amber Alert and the subsequent law enforcement search. Her arrest brought the immediate phase of the investigation to its necessary conclusion and initiated the legal process that would, over the course of the following 2+ years, prove to be far more complicated than most observers anticipated. The complication arose from evaluations ordered by the Franklin County Court in connection with Maye's mental competency, her legal capacity, under Ohio law, to stand trial. Ohio's competency framework requires that a criminal defendant be able to understand the nature of the charges they face and to meaningfully participate in their own legal defense. If a defendant cannot meet that standard due to a mental health condition, they cannot legally be put on trial. They must instead receive treatment and evaluation until competency is either restored or determined to be unrestorable. Franklin County evaluators, after examining Pammy Maye following her arrest and arraignment, determined that she did not meet the legal standard for competency to stand trial. That determination triggered a process that removed Maye from the immediate trajectory of criminal prosecution and placed her in the care of a psychiatric facility for evaluation and treatment, a placement that lasted for an extended period and that left the case in a state of legal suspension for more than 2 years after Darnell Taylor's death. For the people watching this case, for Darnell's family members, for the child welfare advocates who had been following the investigation since February of 2024, for the Columbus community that had been mobilized by the Amber Alert and had followed the subsequent legal developments, the competency determination was a source of profound frustration. The legal system had not abandoned the case. The charges against Pammy Maye had not been dismissed. The prosecution had not ended. But the road to trial had become significantly longer and significantly less predictable. In April of 2026, more than 2 full years after Darnell Taylor was found in that Columbus sewage drain, more than 2 years after the Amber Alert had mobilized the state, more than 2 years after Pammy Maye had been taken into custody, a Franklin County judge reviewed updated evaluations submitted by the psychiatric facility where Maye had been housed and made a formal legal ruling. Pammy Maye had been restored to competency. She now met the Ohio legal standard for standing trial. The case was returned to active criminal proceedings. The defense attorney representing Pammy Maye, in the period following the competency restoration ruling, filed documents with the court indicating the defense's intention to pursue a plea of not guilty by reason of insanity, a legal defense that, if accepted by a Franklin County jury, would not result in a standard criminal sentence, but would instead lead to a different kind of legal outcome in which Maye would be found not criminally responsible for her actions on the grounds that is severe. mental health condition had prevented her from understanding the nature or wrongfulness of what she was doing at the time it occurred. The not guilty by reason of insanity defense is one of the most scrutinized and debated legal defenses in the American criminal justice system. It is rarely successful. It requires a level of proof, typically through expert psychiatric testimony, that is difficult to establish, particularly in cases where the defendant took actions that suggest at least some awareness of the need for concealment, such as hiding remains rather than immediately contacting authorities. Whether Pammy Maye's defense will succeed in convincing a Franklin County jury of her legal insanity at the time of Darnell's death is a question that, as of this documentary's production, had not yet been answered. The trial process was ongoing. For the Ohio foster care system, the case of Darnell Taylor became a catalyst for exactly the kind of uncomfortable systemic review that child welfare advocates had been calling for long before this specific case made national news. How did Pammy Maye pass the screening processes that approved her as a foster parent? What, if anything, in her history or in the home assessment process should have raised flags that were not identified? What oversight mechanisms were in place to monitor the welfare of children placed in her home, and did those mechanisms function as designed? Were there any indicators, from Darnell's school, from neighbors, from any of the institutional touchpoints that children in foster care have, that something was wrong? And were those indicators reported, and were they followed up? Those questions have not all received satisfying answers. The advocacy organizations that work on behalf of children in Ohio's foster care system, organizations that include the Ohio Child Welfare Training Program, Voices for Ohio's Children, and numerous locally based advocacy groups, have used the case of Darnell Taylor as a reference point for pushing state legislators and child welfare administrators to strengthen screening protocols, increase placement monitoring, and invest in the kind of ongoing support and oversight infrastructure that makes foster placements safer for the children at the center of them. Ohio's foster care system serves tens of thousands of children each year. The overwhelming majority of foster parents are exactly what the system intends them to be: caring, stable adults who provide safe environments for children who need them. But the case of Darnell Taylor is the case that illustrates what happens when the system fails. When a child who has already experienced loss and instability is placed in a home that proves to be more dangerous than the situation from which he was removed. Darnell Taylor was 5 years old. He was a child who had been placed in the care of the state of Ohio, and the state of Ohio did not protect him. He was placed in the care of Pammy Maye, and Pammy Maye took his life on Valentine's Day, 2024, and hid what she had done in the sewage infrastructure of the city where he was supposed to be safe. The legal process is moving forward. A Franklin County jury will ultimately determine what legal accountability looks like in this case. And when that process concludes, Darnell Taylor's name will be part of the final record, a record that began with an Amber Alert, continued through 2 years of psychiatric evaluation, and will end in a courtroom where the full truth of what happened to him on February 14, 2024, will finally be placed before a jury and subjected to the full scrutiny of Ohio's criminal justice process. If this case has affected you, please reach out to the Child Welfare Information Gateway at childwelfare.gov for resources related to foster care oversight, reporting procedures, and community support for children in the foster care system. You can also contact the Child Help National Child Abuse Hotline at 1-800-422-4453 if you have concerns about a child's welfare. Darnell Taylor deserved to be safe. The system failed him. The community must demand better. Please like this video, leave a comment, and subscribe to Cold Case Hour. Share this documentary with someone who cares about child welfare in Ohio. These stories need to reach the widest possible audience, and your support makes that happen. Case 4. Michelle Hilyard. May 26, 2021. Franklin County, Ohio. There are cases in which the legal journey from crime to conviction spans years, winding through investigations, legal filings, and courtroom proceedings that test the patience of everyone waiting for resolution. The case of Michelle Hilyard and the death of 4-year-old Bryson Brown in Columbus is exactly that kind of case. One that began in the spring of 2021 and did not reach its final legal chapter until September of 2025, when a Franklin County judge delivered a sentence that the community had long demanded. Bryson Brown was 4 years old. He was a Columbus child whose life ended on May 26, 2021, in circumstances that Franklin County investigators and prosecutors would spend the next 4 years methodically building into one of the most thoroughly documented cases of fatal child abuse the county had prosecuted in recent years. Michelle Hilyard was the woman responsible for Bryson's care on the day his life ended. The investigation that followed his death pieced together what had happened inside the Columbus home where Bryson had been living, and the picture assembled through physical evidence, witness accounts, and forensic examination was one that the prosecutor's office described as clear, documented, and deeply disturbing. According to court records filed in Franklin County, Bryson Brown sustained fatal injuries after Michelle Hilyard struck him multiple times with a board and caused him to fall down a flight of stairs. The injuries he suffered as a result of that incident were catastrophic. Emergency responders were called, but Bryson did not survive. The injuries he had sustained, according to medical examiners, were entirely consistent with severe physical trauma of the kind that could not be attributed to an accident or to any explanation other than direct physical force applied to a child by an adult. The investigation that followed Bryson's death was thorough and deliberate. Franklin County investigators gathered evidence, consulted medical experts, and built a case that they were prepared to take before a jury. That is precisely what happened. Michelle Hilyard did not plead guilty. She did not negotiate a resolution before trial. She contested the charges against her, and a Franklin County jury heard the full weight of the evidence assembled by the prosecution. The jury returned a verdict of guilty. In September of 2025, a Franklin County judge sentenced Michelle Hilyard to life in prison with the possibility of parole after 25 years. The sentence reflected the jury's finding that her actions on May 26, 2021, had resulted in the death of a 4-year-old child, and that the nature and severity of those actions warranted the most serious penalty available under Ohio law for the charges she faced. What emerged during the background investigation and sentencing proceedings added an additional layer of gravity to an already devastating case. Court records revealed that Michelle Hilyard was not appearing before a Franklin County judge for the first time. Ohio state records documented that in 2005, Hilyard had been convicted in Vinton County of sexually abusing 2 of her own biological children, a crime for which she had served a prior prison sentence. That prior conviction meant that when she came back into contact with a child in Columbus years later, the outcome was a second tragedy that the court records suggest did not occur in a vacuum of unknown risk. For child protection advocates, the existence of that prior conviction and the questions it raises about how Hilyard came to be in a position of responsibility over Bryson Brown are among the most urgent issues attached to this case. Ohio law is clear about the rights of children to be protected from individuals with documented histories of child abuse. The gap between what the law requires and what actually happened in the years between 2005 and 2021 is a gap that Franklin County and state-level child welfare authorities have been asked to account for. Bryson Brown was 4 years old. He had 4 years of life, 4 years of the world, of learning, of the ordinary miraculous experience of being a child. Michelle Hilyard took the rest of it from him. She is now serving a life sentence in the Ohio state prison system, and the legal record of what she did to Bryson Brown will stand for as long as those records are kept. Justice was slow in arriving, but it arrived, and Bryson Brown's name is part of that record. If you found this case important, like this video, share it with someone who needs to hear these stories, and subscribe to Cold Case Hour for ongoing coverage of cases that the community deserves to know. Case 5, Sharon Sakoulos. December 31, 2025. Franklin County, Ohio. New Year's Eve is the last night of one year and the threshold of another. A night when most people are looking forward, making plans, counting down towards something hopeful. In Columbus, on the south side of the city, on Orson Drive, the night of December 31st, 2025, ended not with celebration, but with the arrival of emergency first responders to a home where a 3-year-old child had been reported as not breathing. Cassidy Sakoulos was 3 years old. When officers and paramedics arrived at the Orson Drive home that night, they found Cassidy unresponsive. Despite the efforts of first responders, she could not be revived. Cassidy Sakoulos was pronounced deceased. What first responders observed at the scene, physical evidence visible on Cassidy's body that indicated she had suffered harm prior to the call being made, prompted an immediate shift in the investigation from a medical emergency to a criminal inquiry. The woman who had made the call was Sharon Sakoulos. She was Cassidy's mother. Columbus police detectives who responded to the scene and subsequently interviewed Sharon Sakoulos gathered information in the hours and days that followed that would form the foundation of one of the most serious criminal cases Franklin County had processed in the opening weeks of 2026. According to investigators' accounts as reflected in court filings, Sharon Sakoulos told detectives during the interview process that she had intentionally caused Cassidy's death, that she had placed a plastic bag over her daughter's head and sealed it, and that the 3-year-old had not survived. A confession of that nature, in a criminal investigation involving the death of a child, sets a legal process in motion that moves with both speed and gravity. In January of 2026, a Franklin County grand jury reviewed the evidence gathered by investigators, including the physical findings from the scene, the medical examination of Cassidy's remains, and the statements Sharon Sakoulos had made to detectives, and returned an indictment on charges of aggravated murder and child endangerment. Aggravated murder is the most serious charge in the Ohio Criminal Code. It is reserved for cases in which prosecutors allege that a killing was intentional and premeditated, not an accident, not an act committed in a moment of diminished capacity, but a deliberate taking of a human life. The fact that a Franklin County grand jury applied that charge to what happened to Cassidy Sakoulos on New Year's Eve spoke directly to the evidence investigators had placed before them, including Sharon Sakoulos' own words. Following the indictment, Sharon Sakoulos was held in the Franklin County Jail on a bond set at $500,000. As of the time this documentary was produced, the case remained in the pre-trial phase of the Franklin County court system, with proceedings ongoing. For the communities on the south side of Columbus, for the neighbors who lived along Orson Drive, who may have seen Cassidy in passing, who could not have known what was happening inside that house, the case prompted the same questions that arise in every case of fatal child abuse. What were the signs? Who might have seen something? And what would it have taken for someone to make a call that could have changed everything before December 31st arrived? Cassidy Sakoulos was 3 years old. She was at the age when children are discovering the world in the most joyful and uncomplicated way, learning words, learning games, learning what it feels like to be loved unconditionally. She deserved every year that should have followed. The Franklin County court system now carries the weight of her case, and the people of Columbus have not forgotten her name. Please like this video, drop a comment below, and subscribe to Cold Case Hour. These children deserve to have their stories told, and your support keeps this channel going. Case 6, Lashanda Wilder. December 2024. Body discovered April 2025. Franklin County, Ohio. There are moments in a criminal investigation when a discovery so deeply disturbing occurs that it redefines everything investigators thought they understood about the case they were working. For the detectives and officers involved in the investigation of 8-year-old Martonio Wilder's disappearance and death, that moment came in April of 2025, when what had begun as an inquiry into a missing child became something far more devastating. Martonio Wilder was 8 years old. He was a Columbus child, a boy at the age when children are beginning to develop their identities, forming friendships, navigating the social landscape of school and community, learning what the world is and what their place within it might be. He had a name that people in his community knew. He had a presence. And then, at some point in December of 2024, that presence disappeared from the world. The woman charged with responsibility for what happened to Martonio was his biological mother, Lashanda Wilder. Court records filed in Franklin County document a case that, in the language of prosecutors and victim advocates who reviewed it, represented a sustained failure of parental care and human decency directed at a child over a period of time that stretched far beyond a single incident. According to court documentation, Martonio Wilder was subjected to a pattern of severe mistreatment within the home he shared with his mother and her partner. Investigators, through the evidence gathered during their inquiry and through the examination of physical evidence at the residence, documented that Martonio had been confined within the home, deprived of adequate food, and subjected to physical harm over an extended period. The circumstances of his final days, as reconstructed by investigators, reflected a level of cruelty that those familiar with child abuse cases found extraordinary even by the grim standards of the cases they regularly encountered. When Martonio's life ended, the choices made by the adults responsible for him did not end there. Rather than contacting emergency services or taking any step that might have led to accountability, Lashanda Wilder and her partner concealed what they had done. Martonio's body was hidden inside a trash bag and placed in the attic of the home, a fact that investigators discovered during the search that followed reports of his disappearance and the subsequent investigation that brought law enforcement to the residence. The discovery of Martonio's remains in April of 2025 set in motion a legal process that moved with unusual speed. Faced with the evidence assembled by Franklin County investigators, Lashanda Wilder did not take her case to trial. In July of 2025, she entered a guilty plea on charges of murder and gross abuse of a corpse, the latter charge reflecting the manner in which Martonio's body had been concealed following his death. The sentencing that followed the guilty plea produced a term that the court framed as both a consequence and a statement. Lashanda Wilder was sentenced to life in prison with the possibility of parole after 15 years. The sentence acknowledged the severity of what Martonio had endured and the deliberate concealment of his remains, while leaving open, at the far end of 15 years, the legal possibility of a parole hearing at which the full record of the case would be reviewed. For the child welfare community in Columbus and across Franklin County, the case of Martonio Wilder prompted urgent conversations about how an 8-year-old child, a child of school age, a child who would normally be expected to be visible in a community, to be known by teachers and neighbors and other children, could suffer the way court records document he suffered without a single intervention that arrived in time. Those conversations have led to renewed advocacy for mandatory reporting education, for stronger follow-up protocols when children fail to appear at school, and for deeper investment in the community-level support systems that can sometimes see what formal institutions miss. Martonio Wilder was 8 years old. He was a child whose entire life should have been ahead of him. The legal record now stands as the permanent account of what was taken from him and who was responsible. Lashanda Wilder is serving a life sentence. Martonio is remembered. Like this video, leave a comment, and subscribe to Cold Case Hour. Martonio's story deserves to be heard by as many people as possible. Case 7, Melissa Thorp. September 12, 2022. Franklin County, Ohio. In the history of the Franklin County criminal court system, there are cases that stand apart not only because of the harm they document, but because of the specific circumstances under which that harm came to light. Circumstances so far removed from anything investigators could have anticipated that the case becomes, in the minds of those who worked it, permanently unforgettable. The case of Melissa Thorp and the death of her 4-month-old son, Aaron, is one of those cases. Aaron Thorp was 4 months old. He had been alive for 4 months, long enough to be known, to have developed the early patterns of an infant's personality, to have looked up at the world with the complete and uncomplicated trust that very young children place in the adults around them. He lived in downtown Columbus with his mother, Melissa Thorp, in a setting that offered no outward indication to neighbors or community members that anything inside that home was anything other than the ordinary complexity of a young mother caring for a newborn child. On September 12, 2022, Melissa Thorp called emergency services. She reported to the dispatcher that her baby was not breathing. The call initiated a response from Columbus first responders who arrived at the downtown Columbus address, prepared to attempt to save an infant's life. What they found when they arrived was not what any first responder hopes to encounter. Aaron Thorp was not merely unresponsive in the way that medical emergencies sometimes present. The infant's condition, as documented in the first responder reports and subsequently confirmed by the medical examiner, indicated that Aaron had not passed away recently. The state of his remains reflected a period of time during which his mother had not sought medical assistance or contacted anyone who might have intervened, a period during which the infant had been present in the home, while Melissa Thorp had not made any call for help. The medical examiner's investigation into Aaron's death produced findings that transformed the case completely. The autopsy determined that Aaron Thorp had not passed away from a natural cause, from a sudden infant health event, or from any circumstance that a reasonable investigation might attribute to accident or misfortune. The medical examination found evidence of severe injury to Aaron's skull, injury consistent with the application of significant external force that investigators and prosecutors concluded could only have been caused deliberately. Franklin County investigators built a case that was presented to the criminal justice system through the grand jury process, resulting in a charge of aggravated murder against Melissa Thorp. The charge of aggravated murder, under Ohio law, requires prosecutors to demonstrate that the act was both intentional and deliberate, a standard that, in this case, was met through the combination of medical evidence, the circumstances of the delayed call for help, and the totality of the investigation conducted by Franklin County law enforcement. Melissa Thorp did not take her case to trial. In July of 2024, nearly 2 years after Aaron's death, she entered a plea of guilty to the charge of aggravated murder. The guilty plea was a formal acknowledgement, entered into the permanent record of the Franklin County court system, of what she had done to her 4-month-old son. The sentencing that followed produced a term that courts in Ohio apply to the most serious cases of this kind: life in prison with the possibility of parole after 20 years. For Aaron Thorp, who had only 4 months of life, the sentence represents the legal system's clearest statement about what his life was worth and what the law requires of those who take a life of such profound innocence. The case drew significant attention from child advocacy organizations in Central Ohio, many of which highlighted the unique vulnerability of infants, children who cannot speak, who cannot signal distress, who cannot reach any system of protection on their own, and who depend entirely on the adults around them for their survival. Aaron Thorp had no mechanism to reach anyone who could have helped him. The only person who could have made a call made it far too late. Melissa Thorp is serving a life sentence in the Ohio State prison system. Aaron Thorp was 4 months old. The people of Columbus remember him. The courts have rendered their accounting, and the child advocacy community has vowed that his case will continue to inform the training, awareness, and response protocols that determine whether the next Aaron gets a different outcome. If this case touched you, please like, comment, and subscribe to Cold Case Hour. Every person who joins this community helps ensure that these stories reach the people who need to hear them. Case 8, Charity Dreyer. September 2024. Franklin County, Ohio. The Whitehall area sits along the eastern edge of Columbus, a residential community of quiet streets, apartment buildings, and the kind of ordinary neighborhood life that makes up the fabric of a major American city. It is not a place that makes the news for extraordinary reasons. But in September of 2024, a home in the Whitehall area became the center of a Franklin County investigation that would end with a mother sentenced to nearly 2 decades in prison and a 9-month-old child whose name, Araya Williams, would become part of the legal record of Franklin County's most serious child welfare cases. Araya Williams was 9 months old. She was an infant, a child still in the earliest and most helpless phase of human life, dependent in every possible way on the adults responsible for her care. She lived with her mother, Charity Dreyer, along with a 2-year-old sibling, in the Whitehall area home that Columbus first responders were called to in September of 2024 after reports that the infant was unresponsive. When emergency personnel arrived at the residence, they found Araya Williams in a condition that required immediate medical attention. The infant was transported and received emergency care, but she did not survive. The injuries she had sustained were too severe and had occurred under circumstances that medical professionals determined could not be attributed to any natural cause or accidental event. The medical examination conducted by the Franklin County Coroner's Office produced findings that gave investigators the foundation for a serious criminal investigation. Araya had sustained severe trauma to her head and a fracture of her skull, injuries that the coroner's investigation concluded were the result of significant physical force. The nature of those injuries, combined with the other evidence gathered at the scene, pointed investigators directly toward the adults who had been present in the home. What amplified the urgency of the investigation was what first responders observed when they arrived. Not just the condition of Araya, but the condition of her 2-year-old sibling, who was also present in the home. That child showed visible physical signs consistent with abuse, a finding that expanded the scope of the investigation and deepened the concerns of child welfare officials who were notified as part of the response. Charity Dreyer was identified as the subject of the investigation. The case against her was built through the medical evidence, the findings at the scene, and the investigative process that followed. She did not take the case to trial. She entered a guilty plea to charges of involuntary manslaughter and child endangering, charges that reflected the legal framework Ohio law provides for cases in which the evidence establishes that a child's death resulted from the harmful and dangerous conduct of the adult responsible for their care. The sentencing hearing in March of 2025 produced a term that the court imposed under Ohio's sentencing guidelines, an indefinite term of 15 to 20 and a half years in the Ohio prison system. The indefinite structure of the sentence means that Charity Dreyer's time served will be determined in part by her conduct and any parole review processes applicable under Ohio law during her incarceration. The case prompted child welfare advocates in the Columbus area to speak publicly about the patterns they observe in cases involving infants and very young children. The hidden nature of the harm, the absence of any mechanism through which victims of this age can communicate their situation, and the critical importance of the adults and institutions adjacent to at-risk families taking seriously any indication that something may be wrong. For Oriara's sibling, the 2-year-old who was present in that home and who also showed signs of harm, the legal process provided a measure of accountability, but the deeper work of healing and support for that child was entrusted to the child welfare system that stepped in following the investigation. Oriya Williams was 9 months old. She was just beginning, at the very threshold of a life that had barely had time to start. Charity Dreyer is now serving her sentence in the Ohio State prison system, and the case stands in the Franklin County record as a reminder of what the law requires when a child does not survive. Please take a moment to like this video, leave a comment below, and subscribe to Cold Case Hour. Oriya Williams deserves to be remembered, and your engagement helps make that happen. Case 9, Daisha Summers. November 2022. Hocking County, Ohio. Not every case that demands justice moves on a schedule that feels adequate to the loss it involves. Some investigations take months, others take years, and occasionally, a case emerges in which the gap between the event and the formal legal response stretches so long that the mere passage of time becomes its own form of injustice, a gap that families, advocates, and investigators struggle to accept while they wait for a system that moves at its own pace to finally arrive where it should have arrived far sooner. The case of 10-month-old Kailee Summers began in November of 2022. It did not reach the stage of a formal criminal indictment until December of 2025, 3 years after the events that prompted the investigation. In the space of those 3 years, Kailee's mother, Daisha Summers, lived without criminal charges while investigators in Hocking County built the case that would eventually be presented to a grand jury. Kailee Summers was 10 months old. She was an infant in Logan, Ohio, a small city in Hocking County, southeast of Columbus, a community where people know their neighbors and where the circumstances of an infant's hospitalization with severe injuries would not have passed unnoticed by those in the medical and law enforcement community who encountered it. The investigation into Kailee's injuries began when she was brought to a medical facility and examined by healthcare professionals whose findings were, from the outset, deeply alarming. The medical records generated during that examination documented evidence of severe internal trauma and injuries to Kailee's skull, the kind of injuries that medical professionals who work in pediatric trauma are trained to recognize as inconsistent with the explanations most commonly offered by caregivers when children arrive at emergency facilities. The explanation offered by Daisha Summers to investigators from Logan, Ohio, was that Kailee had fallen from a toddler bed. That explanation, a version of events that investigators hear in a significant proportion of cases involving infant and toddler injuries that are later determined to be non-accidental, was evaluated against the medical findings and found by the healthcare professionals and investigators involved to be entirely inconsistent with the nature and severity of what Kailee had sustained. The investigation that followed was extended, methodical, and conducted across the 3 years between Kailee's death and the December 2025 grand jury proceeding. Hocking County investigators worked with medical experts, reviewed the records generated at the time of Kailee's hospitalization, and assembled a case that they concluded met the legal standard for criminal prosecution. In December of 2025, a Hocking County grand jury reviewed that evidence and returned an indictment against Daisha Summers on charges of murder, involuntary manslaughter, felonious assault, child endangerment, and drug possession. The breadth of the charges reflected both the severity of what Kailee had endured and the additional dimension of the investigation that had uncovered evidence of drug-related conduct alongside the primary child abuse allegations. Prosecutors in Hocking County indicated their intention to prosecute the case fully, and as of the time this documentary was produced, the matter was proceeding through the Ohio court system. For the families and advocates who had spent 3 years waiting for this indictment, the December 2025 grand jury action represented both a long-awaited step toward accountability and a reminder of how much work remains in building systems that respond faster. Systems that do not allow 3 years to pass between the death of a 10-month-old child and the moment the legal system formally names a suspect and files charges. The National Children's Alliance and affiliated child advocacy centers across Ohio are among the organizations that work every day to ensure that cases like Kailee's move through investigative and prosecutorial systems with greater speed and coherence. Their work, and the work of child abuse pediatric specialists, forensic interviewers, and victim advocates, is part of the broader infrastructure that exists to ensure that children like Kailee are not forgotten while justice waits. Kailee Summers was 10 months old. She had her whole life waiting for her. The legal system in Hocking County is now moving forward on her behalf, and the people who knew her name long before any indictment was filed are watching every step of what follows. If this case resonated with you, like this video, comment below, and subscribe to Cold Case Hour. Your support means the world and keeps this important work going. Case 10, Billie Jo Tustin. September 17, 2025. Franklin County, Ohio. Every city carries cases that test the limits of what a community can absorb. Cases where the facts, when presented in full, produce a silence in the room that is different from ordinary grief. In Columbus, in the autumn of 2025, the case of Billie Jo Tustin and the death of her 9-month-old son produced exactly that kind of silence. It produced it in the newsrooms that covered the indictment, in the child advocacy offices that tracked the case, and in the Franklin County Courthouse where the legal record of what happened to that infant was formally assembled. The baby's name has not been released in public court records that were available at the time of this production, as is common in Ohio cases where infant victims are involved in ongoing proceedings. He was 9 months old. He was a Columbus infant, a child at the stage of life when babies are beginning to discover the world around them, when they are developing the early patterns of communication that will eventually become language, when every experience is entirely new and the trust they place in their parents is absolute and complete. On September 17, 2025, that infant was transported to a Columbus medical facility with injuries that medical professionals immediately recognized as life-threatening. The injuries he had sustained were severe, trauma to his skull and evidence of injury to the brain, the kind of injuries that the medical team treating him documented and reported to law enforcement in accordance with Ohio's mandatory reporting requirements for healthcare providers who encounter evidence of suspected child abuse. Columbus police detectives who responded to the report and conducted interviews in the days that followed gathered information that led to the arrest of Billie Jo Tustin. In the course of the investigation, according to statements included in court filings, Tustin told investigators that she had reached a point of emotional overwhelm when her infant son would not stop crying. She stated that she had, in that moment, thrown him a distance of approximately 15 feet across the living room of the Columbus home where they lived. The physical consequences of that act were catastrophic. The infant sustained skull fractures and brain injuries that the medical team treating him determined to be fatal. He did not survive. The indictment handed down by a Franklin County grand jury in connection with this case named Billie Jo Tustin on charges of aggravated murder, felonious assault, and child endangerment, a set of charges that reflects the full legal weight Ohio law applies to the intentional killing of a child and to the serious physical harm that preceded his death. What made this case additionally significant in the Franklin County legal record was the indictment that followed against Tustin's live-in boyfriend. He had not been identified as the individual who caused the fatal injuries to the infant. But investigators gathered evidence and testimony sufficient to support a charge of involuntary manslaughter against him on the grounds that he had been present in the home, had been aware of the pattern of harmful treatment directed at the infant, and had not taken any action to protect the child or to report what he knew to law enforcement or child protective services. That charge, involuntary manslaughter for failure to protect a child from known abuse, is one that Ohio courts and prosecutors have applied with increasing intentionality in recent years as part of a broader legal and policy effort to establish that the obligation to protect a child does not rest solely with the person who directly causes harm. Adults who know, who see, and who choose silence bear a legal responsibility under Ohio law, and the indictment of Tustin's boyfriend in this case sent a message to the Franklin County community about the seriousness with which prosecutors are treating that obligation. For the child advocacy community in Columbus, the case of this 9-month-old child became a vehicle for renewed conversations about the critical importance of infant-safe environments, about the support systems available to parents in crisis, and about the resources that exist for caregivers who are struggling before a moment of overwhelm leads to an irreversible outcome. The National Parent Helpline, available at 1-855-427-2286, provides emotional support and guidance for parents who are finding the demands of caregiving overwhelming. Resources exist, help is available, and the tragedy of September 17, 2025, in Columbus, Ohio, stands as the starkest possible reminder of what is lost when those resources go unused. Billie Jo Tustin was indicted on the most serious charges the Ohio Criminal Code provides. Her case is proceeding through the Franklin County court system, and the 9-month-old child whose life ended in a Columbus living room on that September morning is remembered, not as a case number, not as a file in a courthouse drawer, but as a child who deserved every single day that followed. Columbus, Ohio has produced 10 cases in this documentary, 10 children whose names and stories now exist in the permanent record of this channel and in the awareness of every person who has watched to this point. These are not abstract stories. These are real children from real streets in a real American city. They were failed by the people closest to them, and the legal system has responded, case by case, sentence by sentence, indictment by indictment, with the accountability that each child deserved. Cold Case Hour is committed to telling these stories with the dignity, the depth, and the seriousness that the victims and their families deserve. If this documentary moved you, if it made you think, if it strengthened your commitment to advocating for the children in your own community, then it has done exactly what it was made to do. Please like this video, subscribe to Cold Case Hour, leave a comment, and tell us which case stayed with you. Share this documentary with someone who needs to hear it. And check back, because there are more stories to tell, more names to remember, and more accountability to pursue. For every child in this documentary, and for every child whose story has not yet been told, Cold Case Hour will keep showing up.